record. Hello and welcome to CPR's YouTube channel. I'm Russ Bleemer, editor of Alternatives to the High Cost of Litigation. It's a newsletter that John Wiley & Sons publishes for CPR at altnewsletter.com. I am honored to be joined today to discuss the new just posted June cover story by the three authors, well-known mediators from around the country and for many in the conflict resolution world. By well-known, I'm talking about household names here. I'm delighted to be joined by, in alphabetical order, Eric Galton of Lakeside Mediation Center in Austin, Texas. Professor Lela Love, a law professor, director of the Kukin Program for conflict resolution at New York City's Benjamin N. Cardozo School of Law. That's at Yeshiva University. And also Jerry Weiss, the founder of MediationInc in Shaker Heights, Ohio. Their alternatives article is called The Decline of Dialogue, the Rise of Caucus-Only Mediation and the Disappearance of the Joint Session. It presents a survey of veteran practitioners in the International Academy of Mediators on the use of joint session and caucuses in mediation sessions. Now, we all thought going into ADR, the point was to get the parties together. The point of mediation is to produce an agreement out of the shards of conflict. The survey says otherwise. Joint sessions apparently are in decline. Caucuses are on the rise with some regional variations. Why is this? What are the implications of this for mediation practice and for settling cases before the litigation part blows up? Wherever you are on the web joining us, the link to the June issue and the author's article is below. It's free for signed-in members of CPR and, of course, for subscribers. And then there's information on getting the article or subscribing at the link. I'm going to turn it over to the people who uncovered this fascinating mediation trend. First, Cardozo Professor Lela Love. Thanks for joining us, Lela. Why did you undertake the survey on this issue? Had the phenomenon we heard about anecdotally developed into something problematic that needed investigation?
Thank you, Russ. And thanks to CPR for publishing this and providing such terrific support for all three of us doing it. We worked on this article because it seemed like perhaps one of the most important subjects out there right now. I wanted to title this The Death of Dialogue, but my wise co-authors, that's way too bold. It's The Decline of Dialogue. But we live in an age of polarization, whether it's politics or communities or mediation now. There is this decline of people really collaborating and getting together. So why we did it, or let me just speak for myself, is that the thing that excites me personally, and I think my colleagues, about mediation is that it's a process that can bring people together to understand one another better, to collaborate, to come up with ideas to resolve their conflict, and ultimately to come to, in many cases, agreement. And the rise of mediation, where parties are not brought together, seemed like such a huge loss to me. I think to us, because so much of the potential in mediation is making talk work. There's a book by that name, and that's what I think the best mediators in the world do. They make talk work between individuals in high conflict. And just one word about that. So the high conflict part means that when people are in conflict, there's a lot of energy flowing. And that same energy, I believe, gets them in the context of joint sessions where they meet each other to listen as they perhaps would never have a chance to do in their polarized corners. And then with the proper structure and guidance to come up with ideas to make talk work. And one other point before I relinquish this Zoom microphone is so many of us were inspired by the book, Getting to Yes, and the ideas in that book about going to the parties whose dispute it is, uncovering their real interests, getting them to come up with ideas and getting away from the positional bargaining. And this caucus-only mediation really supports a process where there is distributive back and forth positional bargaining, where a mediator presides, helping parties, just get closer to a mid number. So anyway, I'd like to take us back to our roots of making talk work.
That's great, Professor Love. Thank you. I'd like to take that forward to today with Eric Galton. There's no question your results show the decline in increased reliance on caucuses, and we know where Professor Love stands on that. Eric, as of right now, we've seen 15 pandemic months of virtual mediations. How has that affected or increased the use of caucuses versus joint sessions? Is the phenomenon that Professor Love decried just now any better or worse on video? What are the implications of that for joint sessions?
Actually, this is there's been a profound impact. The unintended consequence of the demise of the joint session, which was well underway around the United States long before COVID-19 reared its ugly head. And then all of a sudden, we had to transform the way we do things. We went from a high-touch, in-person environment to an environment where we had to learn how to do Zoom. And so now, for me at least, 300 Zoom mediations later, what is this combination of the decline and virtual mediation mean to all of us? Well, here's what I think it means. What I think it means is one of the central reasons that people had to show up in the same place at the same time for mediation pre-COVID and pre-demise of the joint session was there was going to be a time where everyone's going to be together in the same room. If that's no longer the case, given the logistical, travel, cost savings, and the like associated with virtual mediation, why would people ever want to flock or migrate back to in-person? And I will tell you anecdotally, but I'm positive in the same way I was positive that our survey would reveal what it did, is that if you talk to institutional clients, if you talk to lawyers, if the question is, do they expect virtual not only to survive, but be the dominant form of mediation post-vaccination in COVID? They do. They don't want to spend a day contending with traffic. They don't want to spend 2 days traveling across the country, especially when the mediator, as they see it, is only going to visit with them privately. There's never going to be a combined session. So let me answer your question finally, Russ. And let me tell Lela, I mean, I'm hanging with my dear friends here. I wouldn't have shied away that much from the word death. I wrote an article for the ABA Journal about 7 years ago called The Preventable Death of Mediation. And so I'm not too shy about that one. But one of the really interesting things is that in my Zoom mediations, the joint sessions that I have are more effective than the ones I did in person. Now, is that not a mind-blowing thought? And let's explore just for a moment before I turn it over to my dear friend Jerry about why that actually is. One of the things that I had never considered, there's this great book by Adam Grant right now called Think Again, about rethinking what we do and why we do it. And so COVID, I think, has allowed all of us to kind of rethink a lot of things during this period of transition. Well, one of the things that I've observed about joint sessions online is they tend to, first of all, be more focused. They tend to be less militant, And people's attention spans online appear to be greater than in person. And I think there are two reasons for that. They don't have to worry that the 30 minutes or 40 minutes we're going to spend in joint session watching a presentation is going to make them late for an airplane, or they're not going to get back to their home. And typically they're watching the joint session from a place in which they feel safe and secure. You know, it might be their home. It might be an office that they're familiar with. If they feel stressed, they can pet their dog. If after the joint session is over, they need some way to decompress, they can go downstairs and have a cup of tea. That's one part of it. The other part, I think, is we know from how people learn that 84% of all people learn visually. So people are used to visually digesting information. We've had some remarkable and successful joint sessions using the screen share feature on Zoom, where it really is a sort of learning conversation, learning dialogue. So interestingly enough, virtual has maybe in some respect rescued the use of more effective joint sessions.
Can't hear you, Russ.
Sorry about that. We stayed muted. Jerry, that leaves it to you to decide whether or not we should get people together for purposes of distributive solutions and put more emphasis on joint sessions and bring them back more, or follow from Professor Love, or follow Eric's view, kind of let's go with what we have now, kind of accept the way things are online and work to improve that. The results are the decline in joint sessions. How do we address that in today's environment?
Yeah, I'm going to give you the lawyer's answer, Russ, which is it depends. But I really do think that we can find benefits in both the in-person session and the virtual session. I've had the same experience as Eric has had with virtual sessions. And I find that where before we might have had a lot of emotional avoidance, and we're dealing with an emotionally avoidant population in general. I don't know whether you really thought about it that way, but we're very used to standing behind a bench or a bar or something rectangular and arguing, but we're not very used to being cheek by jowl with people and having an understanding discussion with them. Those of us who have unwrapped this package of conflict thousands of times know that what we find inside is something very, very complex. It's not the simple binary of the legal realm of yes, no, good, bad, right, wrong, win, lose, but rather it's a story about humans involved in a conflict that is usually motored by something much different than that lawyer's syllogism that we talk about in the article of law plus facts equal a conclusion. When we look at the transitions from conflict to resolution, within those transitions, we're looking at transitions from reactive to reflective, from talking to listening, from taking to giving, from transactional to relational. And we can't do those things throwing bombs at each other from remote corners of a negotiation without sitting down and trying to accomplish better understandings. I think there's a huge difference that we don't often enough discern between agreement and understanding. And I think it's the understanding piece that really is served so well by the joint session. People want to move forward, but they want to move forward durably. And to just close a deal for them or with them doesn't allow them to do that. So it takes the art of a skillful mediator to get involved and to really, in some way, whether virtually or in person, employ those strategies and methodologies that are going to allow them to have that understanding conversation with each other that they're not used to in a courtroom.
So people can take the results as they are and apply them as it evolves in the particular situation in front of them. I appreciate that perspective. I want to go back to the beginning. Professor Love alluded to it. That's on the implications of the decline in face-to-face discussions in mediation is something that is characteristic more broadly of some of the things that we're dealing with in our society. You note in the article that mediation, it's a bastion of dialogue and human connection. It's being challenged in an era when dialogue is generally declining due to a variety of factors, political factors, cultural and professional. That's a paraphrase of what you said. Is the decline in dialogue and mediation indeed a symptom of something larger that needs correction? Like maybe can mediation be exemplary of the dialogues that we need to be having more generally in political, cultural, professional, social views? Yeah, that's implicit in a lot of the ADR seminars and events that we've gone to, that we've participated in. Is that at this point a realistic view of the power of mediation?
Russ, I think you said it really well. I believe mediation should be exemplary.
You actually said it really well. I was just giving it back to you. But
you said it really well. And please call me Lela, by the way. So I think, this survey was of the International Academy of Mediators, some of the best mediators in the world. And one of the motivations for me is wanting to inspire mediators themselves to do what they do so well in terms of getting parties together, being exemplary in terms of promoting dialogue. This trend is scary. By the way, maybe the article is misleading. Its data shows that particularly in California, but then spreading eastward to the northeast, there's this sort of Tony Willis calls a caucus-only disease. But around the world, mediation is still a process using joint session vigorously. And I just don't want us all to fall down a hole where that disappears. Since this article was put out, emails from Europe, UK, Hong Kong, Australia, New Zealand say the joint session is alive. The joint session is alive and well. It's you US folks where it's declining. So I want to be a leader, not like a negative leader in terms of promoting dialogue. And just one point that this survey showed, our training programs, our schools are promoting mediation as a place where dialogue happens. It's, I think, the legal marketplace, the lawyers who want a safer, more comfortable process that is a caucus-only type situation, that are leading in terms of pushing mediators to take on the process that the lawyers really want. So I can keep going on forever. You don't want me to do that. So
I wish we had unlimited time, because we could listen to you talk about this issue and bring mediation forward and make it better for a long, long time. Eric and Jerry, do you have any other thoughts on the broader application?
I do. About 4 years ago, I started teaching a course with another friend of ours, Tracy Allen in Michigan, called Restoring Civil Discourse in an Overheated Society, returning to the art of disagreeing without being disagreeable. Because we saw the phenomenon that you spotted, Russ, is that we've gone beyond being an argument culture. It's a vilifying culture. It's a condemning culture. It's not a culture that really values dialogue. In fact, they're afraid of dialogue. People worry whether the Thanksgiving dinner is going to blow up because Uncle Fred is going to say something, and the next thing you know, everything explodes and everybody is miserable and everybody's unhappy. And when you really ask lawyers, Russ, why don't they like the joint session? There's usually two reasons. One is everybody knows what the case is about, although as every mediator who's worth a damn will tell you, when you go in the private session, it's like there's two different cases. They're not the same case. So I'm not sure everyone understands what the case is exactly about. They have their perception of it. And the second is something terrible is going to happen if we have an honest dialogue. Well, I think as the majority of mediators will tell you, it is the rare case in which something blows up at a joint session. Probably in my experience, 7,500 cases, 30 years of doing this, I can only think of one or two or three where that actually happened. And I think part of it is mediators need to be better trained about how to have more effective joint sessions and how to educate lawyers, particularly, how they can be handled in a really constructive way, where good gains are realized instead of negative gains. Part of it also too, I think we sort of have to check our own selves at the door a little bit here. I'm a child of the 60s. That doesn't mean I'm just a dreamer. I'm a pragmatist too. But I don't think that the initial love affair or attraction with mediation was the idea I was going to spend 30 years of my professional life redistributing wealth. The thought of it was there had to be something more to it than that, something more fundamental. And if you talk to veteran mediators like me or Jerry or Lela, or the list is endless, all of us have our share of really remarkable stories where we saw some really, really significant non-economic benefits of the process for the parties, where they left feeling something had really changed in their lives. Their lives maybe were improved, or maybe they had the opportunity to heal because this process gave them something that nothing else really gave them. And it may have been just as simple, Russ, as the opportunity to be heard. And so your question is mediation the forum? Well, in that regard, I think it could be one of the forums. I'm not sure it's the only forum. I think to some extent, we have to get out of our shells of mediators talking to mediators and exporting skill sets that we've learned as a result of these 30 years that we've gone through, and all the education and all the continuing education and all the transformation of our own thoughts, and maybe make it broader to a broader audience. Because I think that all of us sort of feel this collective thought, at least I know I do, I think Jerry does and Lela does, is that we should be able to play a role in restoring civility, restoring dialogue, restoring communication. I think those are worthy goals of mediation and things that we can do that really will make a difference.
Eric prescribes a few remedies for the profession. He was pretty explicit about some more training in helping mediators out, but he was very tough earlier on, Jerry, about the advocates and how they play into the joint sessions in the caucuses. Where do you think that the focus should be to bring the profession forward? Again, I know the answer is it depends and it's all of the above, but what's more problematic for you given the results, taking it back to the article and the survey? Is it the advocates, or is there more training needed? Where should the focus be?
I think when we go to the defaults, Russ, first of all, as far as everything that Lela and Eric said, I'm going to quote Slim Pickens in Blazing Saddles, ditto. But when we look at the defaults of advocates versus the defaults of regular people in conflict, the defaults of advocates are very much oriented towards competition. And that's what they're hired for. That's what they're trained for. The defaults of people in conflict are aimed at sensibilities, pillars of morality, reciprocity, fairness, and the like. And I think we have to concentrate on the disputants. I think that's always got to be the key. That's got to be one of the guiding stars, the North Star of our navigation in this conflict resolution business. What are the interests of the disputants? And I think when we look at the interests of the disputants as far as the desire for a durable outcome, wanting to move forward in a durable manner, that's where we need to be putting our concentration. When you're taking it to the bigger stage that Lela talked about, politics, world peace, world conflict, when you take a look at any one of those great peacemaking efforts in recent history, at least, I think you see processes where something is not forced upon people, but rather where there is a real depth of understanding conversations that take place with them. I don't think we need to go beyond the differences between World War I and Versailles and the Marshall Plan in World War II, where there was a deep understanding of making people who were the former enemy much stronger people and better allies in doing that, back to Adam Grant, in wanting to help people as much in the other room as we want to help ourselves. Adams found that generous negotiators and mediators are probably the smarter negotiators, the smarter advocates, those people who care as much about people in the other room as they do about themselves. So aiming towards the disputants, but trying to nurture something more positive in the advocates. So I think it's a combination platter of both of them.
That's a great plate of aspirational goals for mediation, big and small, and ties it together. Thank you for doing that. And because we're running out of time, I wanted to tie it all together. Jerry, I'll go back to you. What is the takeaway from the article itself in Joint Sessions and Caucuses that you think is most important for the readers? And I'd like to give Eric and Lela a shot at that as well.
I think the takeaway is getting away from the oversimplification that we're too used to in our usual formulae in dealing with conflict, and really having an opportunity to have people understand the complexity of the dispute and the people in the dispute.
Great. Eric or Lela, same question. What's the takeaway?
Okay, let me take a stab at it. We'll let Lela have the last word because she should. I think that the takeaway, as I see it, is I think we've all evolved into the thought that a one-size-fits-all approach to mediation is never a good idea. Mediation should be flexible, and nothing about the article, at least in my opinion, is antagonistic to the notion that there isn't value in caucus. There's great value in caucus. There's great value in joint sessions, and no two cases are the same. So, for example, the evolution for us has been, does the joint session really have to be at the beginning? Maybe we start separately. Maybe we meet in the middle. Maybe we meet at a time when it's more effective. What kind of joint session is it going to be? Is it going to be a learning conversation? Is it going to be an exchange of simply greetings? How are we going to sort of construct all of this? And then, of course, you add the context that you asked about, Russ, which is, well, in virtual, how do we put all of this together? Well, I've got to tell you, I'm really excited again. This whole experiment with virtual and the ability to be creative again, to me at least, feels reminiscent of what it was like in the late 80s and early 90s, when we were sort of developing our thoughts and how we were going to approach all of this. So I think in terms of the joint session, what I'd like your readers to mostly think about is, maybe in this virtual world and maybe in person, we can find ways to more effectively integrate the joint session that achieves goals that both advocates and participants alike can find valuable and useful. So you know, I'm for a guy who like to use the word death a lot, I'm actually cautiously optimistic.
You know, I had death in the headline when I wrote it, when I was putting the issue together. And I just thought that too often people say that it's too negative and we need to support mediation, we need to boost arbitration. So I took that out and I ended up going with your original headline. So now I'm a little bit sorry I didn't go with death. It would have maybe attracted more attention. It was interesting, Eric, that you went back to the 90s. I want to let everybody watching, and as we give Lela the last word, one of the top 10 most downloaded articles since alternatives was digitized was a 1996 article called Is Evaluative Mediation an Oxymoron by Kimberly Kovacs and Lela Love. Lela, are we having the same discussions now about the way mediation is going to be conducted with joint sessions and caucuses that you set the table for on evaluation versus facilitation back then?
Oh, Lord, that's a tough question. So I just think there's a heart and soul of mediation. And part of the heart and soul is that mediators help people talk. Mediators aren't judges. Mediators bring parties together to the table and promote a dialogue and creative problem solving that take people somewhere beyond where they started. So maybe it's the same thing, Russ. I don't think so. I don't hope so. I did want to make one comment. It seems like, or it feels like maybe we're being critical of advocates. And I want to say there's some wonderful, wonderful moves in the world of advocacy that make lawyers among the best negotiators, among the best mediators. They may ultimately put mediators out of business because lawyers know how to bring parties together well. I don't know how many of your readers have been to the Paris International Chamber of Commerce mediation competition. Is desirable now as the Weiss arbitral moot in Vienna. But there, lawyers are competing to law students, some business students, to be good listeners, to be culturally sensitive, to be good problem solvers, to display all the virtues, patience, tolerance, etc., that bring people together. So I think part of the answer is education, that the lawyers need educating. I just don't want mediators to go down a road where mediation becomes either arbitration-like, to go back to that other article, or becomes this less than full process of the caucus only shuttling numbers back and forth. It's just not as exciting a prospect as promoting human understanding and collaborative problem solving.
Russ, you need me to say this. You probably may not know that I'm married to Kimberly Kovacs. And so let me at least say publicly that article that Lela and Kim Kovacs did, it was a great article.
It was a great article. I didn't want to obligate you to do the family disclosure here. I just thought we'd just proceed down the regular professional path. But thank you for bringing that connection up. I wasn't going to do that, but yes, I did. And I hope that in conclusion, that the listeners and the readers of Alternatives are going to go to your websites, Eric at Lakeside Mediation in Austin, where he discloses his family relationship right there. Jerry Weiss in Cleveland at MediationInc, and Professor Lela Love at Cardozo in New York. I want to thank them for getting together and bringing all of these factors together, and ending right there, Lela, with the basics, which we cannot be reminded of enough. So thank you very much for that. Lela had mentioned she's getting some comments already on the article. It's just been posted since on the holiday weekend here in the US. If you have comments, to make it easy, you can send them to alternatives@cpradr.org, and I will pass them on to the authors, and hopefully we'll have a follow-up down the road. Thank you all for joining us and taking the time today.
Thank you, Russ.
Thank you.
Bye.